Hello dear friends. Today we are going to start from Applicability of Companies Act 2013 and key concepts. First one, applicability. According to Section 1 of the Companies Act 2013, the Act extends to whole of India and the provisions of the Act shall apply to the following. A. Companies incorporated under this Act or under any previous company law. B. Insurance companies except in so far as the said provisions are inconsistent with the provisions of the Insurance Act 1938 or the Insurance Regulatory and Development Authority Act 1999. C. Banking companies except in so far as the said provisions are inconsistent with the provisions of the Banking Regulation Act 1949. D. Companies engaged in the generation of supply of electricity except in so far as the said provisions are inconsistent with the provisions of the Electricity Act 2003. E. Any other company governed by any special act for the time being in force except in so far as the said provisions are inconsistent with the provisions of the said special act. And F. Such body corporate incorporated by any act for the time being in force as the central government may by notification specify in this behalf, subject to such exceptions, modifications or adaptation as may be specified in the notification. Companies Act 2013 is not applicable to unincorporated companies. By virtue of Section 464 of the Companies Act 2013, read with Rule 10 of the Companies Miscellaneous Rules 2014, no association or partnership consisting of more than 50% shall be formed for the purpose of carrying on any business that has for its object the acquisition of gain by the association or partnership or by the individual members thereof, unless it is registered as a company under this Act or is formed under any other law for the time being in force. The maximum number of persons which may be prescribed under this section shall not exceed 100. Section 464 of the Act does not apply to 1. In the case of Hindu undivided family carrying on any business, whatever may be the number of its members, and 2. In case of an association or partnership, if it is formed by professionals who are governed by special acts. Key concepts. The Companies Act 2013 has introduced several new concepts and has also tried to streamline many of the requirements by introducing new definitions. Some of the concepts are discussed here in brief. 1 companies, under that 1 person company. The Companies Act 2013 introduced a new type of entity to the existing list, that is, apart from forming a public or private limited company, the Act enables the formation of a new entity, a 1 person company, that is OPC. An OPC means a company with only 1 person as its member. This is given under subsection 1 of section 3. Then private company. The Companies Act 2013 introduced a change in the definition for a private company. Inter alia, the new requirement increases the limit of the number of members from 50 to 200. This is given under clause 68 of section 2. Then small company. A small company has been defined as a company other than a public company. Under that, paid up share capital of which does not exceed 50 lakh rupees or such higher amount as may be prescribed, which shall not be more than 10 crore rupees, and 2. Turnover of which as per the net profit and loss account for the immediately preceding financial year does not exceed 2 crore rupees or such higher amount as the case may be prescribed, which shall not be more than 100 crore rupees. Provided that nothing in this clause shall apply to a holding company or a subsidiary company, a company registered under section 8, or a company or a body corporate governed by any special act. This is given under clause 85 of section 2. Dormant Company, a company formed and registered under this 2013 Act for a future project or to hold an asset or intellectual property and has no significant accounting transaction, and such a company or an inactive company may make an application to the registrar for obtaining the status of a dormant company. This is given under section 455 of the Companies Act. The next is the Nidhi Company. Nidhi Company means a company which has been incorporated as a Nidhi Company with the object of cultivating the habit of thrift and savings amongst its members, receiving deposits from and lending to its members only for their mutual benefit, and which complies with such rules as are prescribed by the central government for regulation of such class of companies. This is given under section 406. Roles and responsibilities. Under that, the first definition that is given is of officer. Officer includes any director, manager, or key managerial personnel or any person in accordance with whose directions or instructions the board of directors or any one or more of the directors is or are accustomed to act. This is given under clause 59 of section 2. Next is key managerial personnel. The term key managerial personnel has been defined in the Act, which means the chief executive officer or the managing director or the manager, the company secretary, the whole-time director, the chief financial officer, such other officer not more than one level below the directors who is in the whole-time employment designated as key managerial personnel by the board, and such other officer as may be prescribed. This is given under clause 51 of section 2. The role and liability have been defined at various places under the Act. The third role and responsibility that is defined as of promoter. The term promoter means a person A who has been named as such in a prospectus or is identified by the company in the annual return, or B who has control over the affairs of the company directly or indirectly, whether as a shareholder, director or otherwise, or C in accordance with whose advice, directions or instructions the board of directors of the company is accustomed to act, provided that nothing in subclause C shall apply to a person who is acting merely in a professional capacity. This is defined under clause 69 of section 2. Next is independent director. The term independent director has been defined in the Act along with several new requirements relating to their appointment, roles and responsibilities. Independent director means an independent director referred to in subsection 6 of section 149. Next is audit and auditors. Mandatory auditor rotation and joint auditors. The Act mandates the rotation of auditors after the specified time period. It is given under section 139. Secretarial Audit. The Act mandates secretarial audits for the following: listed company, every public company having a paid-up share capital of 50 crore rupees or more, every public company having a turnover of 250 crores or more, and D, every company having outstanding loans or borrowings from banks or public financial institutions of 100 crore rupees or more. The Secretarial Audit Report is required to be annexed to the Board's report that is mentioned in section 204. Secretarial Standards. The Act requires every company to observe secretarial standards specified by the Institute of Company Secretaries of India with respect to general and board meetings. This is given under subsection 10 of section 118. Corporate Social Responsibility. The Act introduced the culture of corporate social responsibility, that is CSR, in Indian corporates by requiring companies to formulate a corporate social responsibility policy and at least incur a given minimum expenditure on social activities. Class action suits. The Act introduces a new concept of class action suits which can be initiated by shareholders against the company and auditors. Formation and incorporation of companies. Subsection 1 of Section 3 states that a company may be formed for any lawful purpose by A. 7 or more persons where the company to be formed is a public company, B. 2 or more persons where the company to be formed is a private company, or C. 1 person where the company to be formed is to be a one-person company, that is to say a private company by subscribing their names or his name to a memorandum and complying with the requirements of this Act in respect of registration. A company formed under subsection 1 of Section 3 may be either a company limited by shares or a company limited by guarantee or an unlimited company. Subsection 1 of Section 7 of the Act provides for the detailed procedure for incorporation of companies. There is a note that is given. For details on types of companies and formation of companies, you may refer page 3 of the module 1, that is setting up of business entities and closure. Important definitions. Section 2 of the Companies Act 2013 contains definitions. Clause 20. Company means a company incorporated under this Act or under any previous company law. Clause 21. Company limited by guarantee means a company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. Clause 22. Company limited by shares means a company having the liability of its members limited by the memorandum to the amount, if any, unpaid on the shares respectively held by them. Clause 68. Private company means a company having a minimum paid up share capital as may be prescribed and which by its articles restricts the right to transfer its shares, except in case of one-person company, limits the number of its members to 200, provided that where 2 or more persons hold 1 or more shares in a company jointly, they shall for the purpose of this clause be treated as a single member, provided that persons who are in the employment of the company and persons who have been formerly in the employment of the company were members of the company while in that employment and have continued to be members after the employment ceased shall not be included in the number of members, and prohibits any invitation to the public to subscribe for any securities of the company. Clause 71. Public company means a company which is not a private company and has a minimum paid up share capital as may be prescribed, provided that a company which is a subsidiary of a company not being a private company shall be deemed to be a public company for the purpose of this Act, even where such subsidiary company continues to be a private company in its articles. Clause 46. Holding company in relation to one or more other companies means a company of which such companies are subsidiary companies. Explanation. For the purpose of this clause, the expression company includes any body corporate. Clause 87. Subsidiary company or subsidiary in relation to any other company, that is to say the holding company, means a company in which the holding company controls the composition of the board of directors or exercises or controls more than 1/2 of the total voting power either at its own or together with one or more of its subsidiary companies, provided that such class or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such numbers as may be prescribed. Explanation. For the purpose of this clause, a company shall be deemed to be a subsidiary company of the holding company even if the control referred to in subclause 1 or the subclause 2 is of another subsidiary company of the holding company. B. The composition of the company's board of directors shall be deemed to be controlled by another company if that other company by exercise of some power exercisable by it at its discretion can appoint or remove all or a majority of the directors. C. The expression company includes any body corporate. And D. Layer in relation to a holding company means its subsidiary or subsidiaries. Before going to discuss body corporate, it is prudent to discuss associate companies. Clause 6 Associate company in relation to another company means a company in which that other company has a significant influence but which is not a subsidiary company of the company having such influence and includes a joint venture company. Explanation for the purpose of this clause. The expression significant influence means control of at least 20% of total voting power or control of or participation in business decision under an agreement. And B. The expression joint venture means a joint agreement whereby the parties that have joint control of the arrangement have rights to the net assets of the arrangement. Clause 11 Body corporate or corporation includes a company incorporated outside India but does not include a cooperative society registered under any law relating to cooperative societies, and B that is 2 any other body corporate not being a company as defined in this act which the central government may by notification specify in this behalf. Clause 42 Foreign company means any company or body corporate incorporated outside India which A. has a place of business in India whether by itself or through an agent, physically or through electronic mode, and B. conducts any business activity in India in any other manner. Clause 42 Listed company means a company which has any of its securities listed on any recognized stock exchange. Clause 45 Government company means any company in which not less than 51% of the paid up share capital is held by the central government or by any state government or governments, or partly by the central government and partly by one or more state governments, and includes a company which is a subsidiary company of such a government company. Clause 9 Banking company means a banking company as defined in Clause C of the Section 5 of the Banking Regulation Act 1949. And Clause 39 Financial institution includes a scheduled bank and any other financial institution defined or notified under the Reserve Bank of India Act 1934. With the lesson roundup, we are coming to the end of Chapter 1. The lesson roundup says the word company is derived from the Latin word com is equal to with or together and pan is bread, and it is originally referred to an association of persons who took their meals together. The main characteristics of a company are corporate personality, limited liability, perpetual succession, separate property, transferability of shares, capacity to sue and be sued, contractual rights, limitations of action, separate management and termination of existence, etc. The company, though a legal person, is not a citizen under the Citizenship Act 1955 or the Constitution of India, though it has established through judicial decisions that a company cannot be a citizen, yet it has nationality, domicile and residence. In India after independence, the Companies Act 1956 was enacted with a view to consolidate and amend the earlier laws relating to companies and certain other associations. Major developments in the company law in India and the last where a fraudulent and dishonest use is made of the legal entity, the individuals concerned will not be allowed to take shelter under the corporate personality. The court may break through the corporate shell and apply the principle of what is known as lifting off or piercing the corporate veil. Under glossary, jurisprudence, ordinance and bill are defined. Jurisprudence is the study of law and the principles on which law is based. Ordinances are temporary laws that are promulgated by the President of India on the recommendation of the Union Cabinet. Article 123 of the Constitution of India provide for the power of President to promulgate ordinances during recess of Parliament. They enable the government to take immediate legislative action. Ordinances cease to operate either if Parliament does not approve of them within 6 weeks of reassembly or if disapproving resolutions are passed by both houses. It is also compulsory for a session of Parliament to be held within 6 months of passing an ordinance. Bill. A bill is proposed legislation under consideration by a legislature. A bill does not become law until it is passed by the legislature. Once a bill has been enacted into law, it is called an act of the legislature or a statute. With this, we come to the end of chapter 1. From the next audiobook, we will be listening to chapter 2. Chapter 2 is Share and Share Capital. Thank you, friends. Stay safe.